Welcome once again to the 2026 Green Law Global Initiative International Moot Court Competition on Climate Justice and Environmental Governance. Before we kick off, I will give it to our IT team lead, Simon Makesa, to lead us in a virtual group photo, and then we can proceed. Simon, take over.
Thanks a lot, Brian. I'd like to urge all of you to open your cameras so that you can take a virtual photo. So kindly open your cameras. Kindly let us open the cameras. All right. Kindly. Good. We're still waiting for the three. Kindly open your cameras. All right, I'll be taking the photo in 1, 2. All right. Thank you. That's all.
All right, thank you, Simon. Now we transition into the virtual courtroom. I'll be your court assistant for today. My name is Brian Awunda, and I am the court assistant for this session. Welcome to the fourth preliminary round of the Green Law Global Initiative Climate Justice International Moot Court Competition 2026. The matter before this honorable court is between Chuka University, Kenya, representing Azania, versus Catholic University of Eastern Africa, still from Kenya, representing SECA. The honorable bench for this session consists of Senior Counsel Eric Theory, presiding judge, Judge Grace Njoki, and Judge Cynthia Odongo. I now respectfully invite the honorable judges to take the bench. The court is now in session. I respectfully hand over the proceedings to the honorable presiding judge. Welcome, presiding judge.
Thank you, Brian. Good evening, everyone. We are now officially in session. The matter has been called out. We would then invite the counsel representing Azania. I want to believe they have, is it 30 minutes to make out their case?
Yes, presiding judge. Yes, presiding judge.
Thank you so much. So the judges having been introduced, may I invite the team counsel representing Azania to make out their case before us. You will have 30 minutes. I hope that in the process you'll be able, as you begin, to give us how you intend to make your arguments so that we can be able to follow you. The court clerk will give you an indication when your time is just about to run out. So I invite counsel from Azania to make their case.
Thank you very much, presiding judge. Mr. President, Your Excellencies, good evening. And may it please this court.
Kindly please, Rachel, you're logged in twice. I think you need to log out for one. There are some echoes on your side.
Is that better?
Much better.
Thank you. Presiding Judge, Mr. President.
Proceed.
Thank you. Mr. President, Your Excellencies, good evening and may it please this court. My name is Rachel Praise Wafula, lead agent for the state of Azania. Together with me is co-agent Peter Manuele. I'll be taking 15 minutes of this court's time to handle the issue of jurisdiction, issue 1, 2, 3. And Peter Manuele will be taking 15 minutes of this court's time to present on issue 4, 5, and 6. We would like to reserve 10 minutes for our rebuttals. Your Excellencies, This case arises at the intersection of climate change, international trade, and state responsibilities, and it concerns the legality of Azania's regulatory response to the environmental harms associated with second-hand apparel trade. The central question before this court is whether the international law permits and indeed requires such regulatory action, even where it affects transboundary trade. And the state respectfully submits that it does and will proceed to argue our case accordingly. Onto the issue of jurisdiction and admissibility, the state respectfully submits that the jurisdiction of this court is properly invoked. The present proceedings arise from a request for an advisory opinion submitted to the court pursuant to Article 96 of the Charter of United Nations, read together with Article 65 of the Statute of the International Court of Justice, which empower this court to render advisory opinions on legal questions at the request of a duly organized organ, authorized organ, such as the UN General Assembly in this particular case. The state further submits that there are no compelling reasons for this court to decline jurisdiction, and therefore we urge this honorable court to provide guidance on matters of global importance such as this. On to the first issue of whether the ICJ advisory opinion affirms a positive obligation on states to regulate transboundary value chains. And in this issue, the state avers a yes, and we submit that the advisory opinions affirms that states have a legal duty to prevent significant transboundary harm by exercising due diligence over activities within their jurisdiction, including regulating private entities and supply chains that contribute to greenhouse gas emissions. This position finds authoritative grounding in the Trail Smelter arbitration case, where it was established that no state has the right to use or permit to use its territory in a manner that causes injury onto another state. This principle was later reaffirmed in the case of Kofu Channel. Under Article 41B of the UNFCCC, states are required to formulate and implement programs in order to mitigate climate change by addressing emissions from various sources. This obligation is further strengthened by Article 4 of the Paris Agreement. Applying the foregoing principles, we submit that first, the nature of climate change as a transboundary cumulative harm necessitates proactive intervention by the state of Azania. Although framed as a circular economy, the facts still opine that up to 45% of the imported textiles are unsellable waste. These contribute to environmental degradation. Secondly, the state's obligations under the UNFCCC and the Paris Agreement require it to take nationally determined mitigation measures. Regulation of the textile imports is a legitimate and necessary means of fulfilling these obligations. The state therefore submits that the measures are not merely permissible, but legally required under international environmental law as clarified by the advisory opinion of 2025. Your Excellencies, I will proceed to the second issue, and that is whether Azania's failure prior to the TWC-CUEA constituted a breach of due diligence. Your Excellencies, members of the court, the state respectfully submits that Azania did not breach its due diligence obligations prior to the enactment of the Act. First, due diligence obligation requires states to take reasonable measures in light of their capacity and knowledge at the very material time. As seen from the facts of the case, prior to the advisory opinion, the specific link between second-hand apparel imports and climate change was not sufficiently crystallized in law. And as such, absence of targeted regulation cannot be construed as a failure to meet the clearly established legal obligation. Secondly, Secondly, Your Excellencies, as underscored by the pulp mills case Argentina versus Uruguay, due diligence is a variable standard. It varies according to the level of risk and means available to the state at the material time. According to Part A, if the court will move with me to Part A of the factual matrix, Tanzania, as a developing state, was entitled to take into account its economic and technological capacities. The regulation of the complex global supply chain, such as second-hand apparel trade, requires significant administrative and infrastructural resources. Thirdly, Your Excellencies, due diligence obligation is one of progressive implementation as underscored by the UNFCCC and the Paris Agreement. Article 2 of the International Covenant on Economic and Social-Cultural Rights acknowledges the progressive realization by stating that states are only required to move expeditiously using the maximum available resources. The state submits, Your Excellencies, that the state of Tanzania cannot fix the systemic industrial issues overnight. And eventual enactment of the TWCCEA demonstrates the good faith compliance with the evolving international obligations rather than prior breach. The conclusion in this issue is that we submit that the due diligence obligation is one of responsible conduct assessed in context, and Tanzania acted within the bounds of its capacity and evolving legal expectations. Unless court seeks any clarification, I'd like to proceed to the third issue of whether the measures adopted pursuant to the ICJ advisory opinion may justify limitations on international trade. Your Excellencies.
With your kind indulgence, Presiding Judge, just allow me to request the counsels for SECA to switch on their cameras. Nick Kimathi and Timothy Kamore. Your cameras should be on at all times.
You can proceed now, Rachel.
Thank you, Mr. President. On the third issue of whether the measures adopted pursuant to the ICJ advisory opinion may justify limitations on international trade, the state avers that the measures adopted indeed justifies the limitations on international trade. States are under the obligation to take effective measures to mitigate climate change and private environmental harm. This position is grounded in the principle of sustainable development as articulated by this very court in the Gabsikovo-Nagimoros project case, where this court emphasized the need to reconcile economic development with environmental protection. It is on this very premise that we submit the measures adopted are lawful, justified, necessary, and proportionate to mitigate environmental harm. First, Your Excellencies, we submit that the duty of due diligence and prevention of harm is an important principle of environmental law as stated in the pulp mills case. As I have sufficiently exhausted under the second issue, and I will not wish to reiterate, save for stating that the state's due diligence obligations include the obligation to regulate private actors whose activities cause environmental degradation. If this honorable court will move with me to Part B of the factual matrix, we see that up to 45% of the imported garments are unsellable waste. We submit that Tanzania's measures are proportionate because they target the very source of environmental harm, which is low-quality imports, while still allowing legitimate circular economy to function. Secondly, Your Excellencies, the international trade law explicitly permits environmental limitations. Under the General Agreement on Tariffs and Trade, Article 20B and G underscore that the restrictions are justified if they are, one, necessary to protect human, animal, or plant life or health, and number two, if they are related to the conservation of exhaustible natural resources. Honorable members of the bench, the TWCCEA's minimum
You're muted, Praise.
Oh, I'm sorry for that. Let me repeat the point. The TWCCEA's minimum quality threshold and digital traceability are essential to prevent toxic emissions from textile burning and microplastic pollution to marine environments, which directly affect the state of Azania being a coastal state. In the case of Burlington Resources versus Eucador, the case elaborates on the proportionality principle. The case stated that the case states that the proportionality is frequently applied in investor-state disputes in order to determine if the environmental regulations constitute indirect expropriation of environmental rights. Honorable members of the bench, we persuasively rely on the Kenyan Supreme Court case of Fatuma Athman Faraj versus Ruth Faith Mwasi and two others, which established the four-part proportionality test for limiting rights, which is also found in the R versus Oaks Canadian Supreme Court case. These are the Oaks tests. And the first one is the limitation must pursue a legitimate objective that justifies the restriction. Number two, the measure must be suitable, meaning it has to be capable of achieving the intended goal. Number three, the measure must be necessary. And number four, the benefits of achieving the objective must outweigh the harm caused to those whose rights were violated. Those whose rights are affected. Based on these and the foregoing principles, we submit and I conclude on this issue that the measures adopted by Azania are lawful and justified limitations are grounded on the state's obligations to protect and uphold environmental protection. That is the end of my submission. If the court seeks no clarification, I'd like to cede the floor to second counsel to proceed. Thank you and most obliged.
Thank you so much, counsel. May I just make an inquiry if Judge Cynthia, you have any question or clarification you may seek?
Yes. Just one clarification, presiding judge. Praise, I'd like you had mentioned that the state should take measures during your argument. What do you think are these? What can you suggest? You did not enumerate any specific measures that the state can take. Can you give us some of these mitigating measures?
Thank you very much, Madam President, for the question. Some of the measures that the state can undertake includes implementing regulations and frameworks in order to regulate the production of the green gas or the emission of green gas by second-hand apparel companies. Yes, yes.
Judge, you are okay with that?
I'm sure there are some others that you might have come across throughout your research. Is there any, apart from regulation, is there anything extra that the state can do in order to mitigate such cases?
Thank you. Other measures that can be taken will be extensively covered by co-counsel, but if I can just mention one more, is the engagement between government entities and those who are in the circular economy. For example, yes, through this, they can come up with policies and frameworks in order to ensure that there is minimal emissions of greenhouse gases. However, more on this will be covered by my co-agent.
That's noted. Thank you.
Yeah, thank you so much, Judge Njoki. Do you have any issue you'd want clarified?
Yes, thank you, President. Thank you, Praise, for your arguments. I wanted to understand your position on how Azania is characterizing the advisory legal opinion. Are you considering it binding or advisory? How is your characterization? Because I think during the argument that did not come out quite clearly.
Thank you for the question, Madam President. And on that particular issue, we submit that the advisory opinion by the ICJ is not binding as per Article 96 of the UN, the Charter of the United Nations. However, this advisory opinion helps shape policies and frameworks that Azania can take in order to mitigate climate change and the adverse effects of environmental harm caused by second-hand apparel management. And further, yes, that will be our submission. And inside still within the advisory opinion, there are binding laws, for example, the UNFCCC and the Paris Agreement, which are binding upon states when it comes to matters on climate change mitigation and prevention of transboundary environmental harm.
All right, thank you. And just a follow-up question to what Judge Cindy asked on some of the measures Azania would take mitigating measures. I want to tie this to your second argument on due diligence. And do you think that there was a failure in due diligence by the Azania state in failing to provide regulations for the second-hand apparel? Do you think this constitutes a failure on due diligence? Because without this regulation, then we saw the environmental harm to the stakeholders within the coastal lines. So is it your position that the due diligence may have failed by the Azania state?
Thank you for the question, Madam President. And it is our government that, as I stated under the second issue, that the state of Azania did not fail in its due diligence obligation, majorly because the obligation of due diligence, as underscored under the UNFCCC and the Paris Agreement, is one of progressive implementation. Under Part A of the fact sheet, it states that the state of Azania is a middle to lower class state, and therefore it will take progressive realization of this due diligence principle in order to fully implement it. And that is what we did by eventually enacting the TWCCEA, which had regulations that govern second-hand apparel waste. Through that act, it provided for the regulations to help in the due diligence principle.
Thank you, Praise. That's it from me.
Thank you. I think Judge Njoki, you asked a question that I had wanted to pose. So in the interest of time, I will now invite Council Peter to make his arguments.
Much obliged.
Mr. President, Your Excellencies,
There's
this Honorable Court.
Council, just one second, there is some echo. I don't know whether it could be coming from two different devices or...
Most obliged, Your Honor, I have resolved the matter.
Thank you, you can proceed.
Once again, Your Excellencies, and may it please this Honorable Court, for purposes of record, my name is Peter Manuele, picking on the baton from my co-counsel Rachel Praise, and I shall be taking the remaining minutes of the time graciously allocated to us to address the court with respect to issue 4, 5, and 6. On issue 4, whether digital traceability and extended producer responsibility requirements constitute lawful regulatory measures or unlawful discrimination against informal economic actors. Your Excellencies, Azania respectfully submits that these requirements under the Textile Waste Control and Circular Economy Act are permissible regulatory measures grounded in established principles of international, environmental, and trade law. Your Excellencies, to begin with, international environmental law requires states to take measures to prevent any environmental damage and harm from occurring. We seek to persuasively place reliance in the pulp mills case, where this particular court, under paragraphs 197 and 101, stated that this obligation requires states to exercise due diligence by constantly monitoring and administering means to ensure that their activities do not harm the environment. Your Excellencies, digital traceability mechanisms directly implement this regulation by allowing authorities to trace the flow of imported clothing, identify waste sources, and regulate environmental compliance standards. Your Excellencies, in addition to this, the EPR requirement operationalizes the internationally accepted polluter pays principle, that those who cause environmental damage must bear the cost of that particular damage. Your Excellencies, what this particular principle does is that it holds importers and producers accountable for the environmental footprint of their products throughout their life cycle, preventing any transfer of costs to the public or future generations. Moreover, Your Excellencies, the Azania's regulatory framework complies with international treaties governing transboundary waste management. And under Article 4, specifically paragraphs 2 and 6 of the Basel Convention, it requires states to manage the waste in an environmentally sound manner. Much of the imported second-hand clothing becomes unsellable when it lands and goes straight to waste, as has been explicitly stated under the factual matrix, specifically Part 2. Therefore, Your Excellencies, controlling these imports under traceability and EPR thus amounts to compliance with binding treaty obligations and not discriminatory. Your Excellencies, the measures satisfy the constantly used proportionality test. First, their suitability derives from the fact that digital traceability answers environmental risks of textile waste. Second, they are necessary because no equally effective mechanism exists for monitoring waste flows and compliance. Third, it is proportionate since the benefits for the environment, such as reduction in pollution, improved waste management, and protection of public health, among others, outweigh the economic burden imposed on the regulated actors. And we seek to persuasively place reliance in the 2007 Brazil reiterated case, where the World Trade Organization asserted under paragraph 140 that and established that countries have the right to decide on an appropriate level of environmental protection, even if it involves economic costs. In the end, Your Excellencies, the absence of these regulations will make the state internationally liable according to the International Law Commission Articles on State Responsibility under Article 2, where it defines that an internationally wrongful act occurs when a state fails to fulfill an international obligation. Your Excellencies, this failure to monitor and ensure accountability will mean that the state has failed in its due diligence obligation. Your Excellencies, These digital traceability and EPR requirements are like a seatbelt. They may seem burdensome at first, but they exist to prevent predictable harm. Therefore, Your Excellencies, Azania submits that these requirements are regulatory measures that are lawful, necessary, and proportional, and are consistent with international human rights law and environmental and trade law. Permit me, Your Excellencies, to address the court with respect to issue 5 on whether failure to regulate apparel-related pollution will violate international human rights obligations, including the principle of intergenerational equity. Your Excellencies, Article 24 of the African Charter on Human and People's Rights recognizes this right and establishes that all peoples have the right to a general, satisfactory environment favorable to their development. Your Excellencies, what this provision does is that it places a negative and positive obligation on states to prevent the degrading of the environment and to regulate activities that threatens the integrity of the environment. And this position has been propounded as well in the Serak versus Nigeria case, where the Commission explained this obligation under paragraph 52 and held that states must avoid the pollution of the environment, protect communities from such pollution, and conduct regulatory controls over private actors whose activities may pollute the environment. Your Excellencies, international law obliges states to provide special protection to children because of their vulnerability. And this has been aptly stated under Article 14 of the African Charter on the Rights and Welfare of the Child. And this as well has been canvassed by the UN Committee on the Rights of the Child in its General Comment number 26 of 2023, where it recognized that climate change and environmental degradation are threats to children's rights. It also affirmed the obligation of states to regulate environmental hazards for children. Moreover, Your Excellencies, states must safeguard environmental resources for future generations as an obligation to uphold the principle of intergenerational equity, which has been well propounded in the Minors Opposer for the Secretary of Environment, wherein the Supreme Court of the Philippines reinstated the right of future generations to a healthy environment. This particular principle has also been affirmed in Peter K. Waweru vs. Republic under paragraph 26, where the court established the trust obligation to manage natural resources for future generations. Your Excellencies, this particular court reaffirmed this idea in its advisory opinion on climate change of 2025, which states that policymakers must take into consideration the rights of the future generations and clarify that intergenerational equity is a legally relevant interpretive principle. Your Excellencies, a famous quote by Chief Seattle reflects this principle when he stated that we do not inherit the earth from our ancestors, but we borrow it from our children. Your Excellencies, failing to regulate pollution that harms children is like knowing a well is contaminated, but continuing to let families drink from it. The risk is foreseeable and the duty to act is immediate. Your Excellencies, Azania is therefore required to regulate pollution from clothing to provide protection to present and future generations. The Textile Waste Control and Circular Economy Act is therefore a reasonable and legal implementation of this particular duty. Permit me, Your Excellencies, to address this court with respect to issue 6, whether social enterprises operating within circular economy models may function as legitimate governance actors in fulfilling state climate obligations. Your Excellencies, public and private actors have a vital role to play in climate mitigation and adaptation measures. And this has been captured under the Paris Agreement, particularly Article 6, where the agreement encourages partnerships to further resource efficiency and environmental sustainability. Your Excellencies, circular economy businesses like recycling operations and second-hand clothing shops contribute crucially to these aims by extending product lifespans, limiting waste generation, and curtailing the use of natural resources. Your Excellencies, the Global Waste Management Outlook of 2015, published by UNEP, recognized that recycling and reuse industries are key components of effective and environmentally sound management. Your Excellencies, the decision of whaling in the Antarctic, where this particular court emphasized in its judgment under paragraph 60 to 62, the need for scientific and institutional actors in environmental regulation and monitoring. This decision reiterated that the contracting government decisions must involve consultations with these institutional actors to ensure proper management. Likewise, Your Excellencies, technical competence, operating capacity, and field level implementation strengthened the regulatory power of social enterprises. Your Excellencies, a function of social enterprises, is in line with the Sustainable Development Principle, which this particular court reiterated under paragraph 140 in the Gabsikovo-Nejimaros project case, whereby environmental factors in particular must be integrated into development planning. Your Excellencies, circular economy enterprises exemplify this concept as they facilitate eco-friendly economic activities while generating jobs and enhancing community livelihood. Your Excellency,
you have 5 minutes.
Thank you for your grace. Moving on, Your Excellencies, acknowledging social enterprises doesn't absolve the state of its primary duty to protect the environment. Instead, it involves strengthening the state's capacity to fulfill its obligation through community-based approaches and private sector innovation. Your Excellencies, the cooperative governance model about international environmental law is indicative of the trend of joint action and common but differentiated responsibility. Your Excellencies, addressing climate change is like fighting a wildfire. The state leads the response, but success depends on every trained hand joining the effort. As such, Your Excellencies, the Republic of Azania opines that social enterprises operating within the systems of circular economy are legitimate environmental governance partners of the state, whilst also allowing the state to fulfill its climate obligations under international law. Your Excellencies, with the permission of this honorable court, allow me to submit on our reliefs. Your Excellencies, the Republic of Azania respectfully seeks clarification that this court makes a clarification that states enjoy sovereign regulatory discretion to design and implement environmental and climate legislation, including circular economy laws such as the Textile Waste Control and Circular Economy Act, in pursuit of legitimate public interests. Your Excellencies, we are also persuading this honorable court to make a clarification that the International Court of Justice advisory opinion on climate change, while authoritative and persuasive, is non-binding and leaves states with flexibility in determining appropriate regulatory measures suited to national circumstances. Your Excellencies, we are seeking a clarification from this court to clarify that the Textile Waste Control and Circular Economy Act constitute a lawful, necessary, and proportionate response to climate change, environmental degradation, and transboundary textile waste consistent with international climate, environmental, and human rights obligations. And finally, Your Excellencies, we are seeking this court to make a clarification that effective climate action requires coordinated international cooperation, but the absence of comprehensive global regulation does not preclude states from adopting robust domestic measures to meet their international obligations. At this point, Your Excellencies, I wish to rest our case unless the court requires any clarification on our part. Thank you very much.
Thank you, Counsel, and thank you for managing your brief within the time allocated by the court. Judge Njoki, any issue you would want clarified from the submissions that we've just had?
Mr. Peter, could you kindly speak over the stance of Azania in terms of proportionality in summary? How have you treated it?
Thank you, Your Excellency. Just a bit, I retraced the point where I mentioned I canvassed the particular test of proportionality, where the measures must satisfy the constantly used proportionality test, which was also mentioned by my co-counsel when she addressed this proportionality test, as was advanced by the Canadian Supreme Court in the Republic versus Ox case, where proportionality test, first, it must ensure that the suitability derives from the fact that, in this particular case, the fact that digital traceability answers environmental risks of textile waste. And the environmental risks in this particular matter include pollution, landfills of the rivers, which ends up polluting the environment. And on the issue of they must be necessary, Your Excellencies, it is Azania's position that there is no equally effective mechanism that exists for monitoring waste flows and compliance. I don't know if that answers your question, Your Excellency.
It doesn't. Allow me to do a follow-up. What less restrictive measures would then Azania apply, considering we're discussing proportionality of the law? What example, and this ties to the question my co-judge had asked Praise earlier on, what less restrictive measures can be applicable? Because then we're not saying...
Thank you, Your Excellency.
Okay, sorry, go on.
Thank you, Your Excellency. I do note your concern. Maybe the other alternatives that may exist that we may have captured, but if you look at the 2007 Brazil retreated tires case, where the World Trade Organization established that countries have the right to decide on an appropriate level of environmental protection, even if it involves economic costs. We may have other alternatives such as compliance agreements or even test approaches. But in this particular case, it is a risk. It is a foreseeable risk which the state ought to put in measures. And one of the measures is actually, it is the position of the state of Tanzania that it was not actually doing away with a circular economy, but actually it was trying to put in measures that may tend to regulate the use, actually the end life cycle of that particular product. Most notably because of the nature of this particular country, since it is still a growing economy. Therefore, the waste management may not be really effective. And therefore, because most of these apparels originate from the global north to the global south, then it obliges, when regulating, putting in a law that holds accountable the producer of that particular product, it will follow up to the life cycle and help enable maybe the producer, even the consumer of that particular item, to maybe manage the waste or dispose it in an environmentally friendly way.
Thank you. That's it for me.
Thank you so much. Judge Cindy, anything you want to clarify?
I think I had the same issue, Judge Njoki. It has been dealt with.
Thank you so much. Peter, may I just make a very small inquiry from you? There's a decision you quoted, the decision of, is it Peter Waweru versus Republic? How would you want us to treat that decision?
Naskia.
Are you able to get my question? Did you get my question? Can you hear me?
Peter and Praise, is your network okay? Can you hear the Honorable Court?
Yes, I can.
Can Peter hear the court? The court has asked him a question. Okay, that's better. Then mute the other one, log out. You're muted.
Peter, can you unmute?
Yes, I'm kindly requesting the Honorable Judge to kindly repeat the question because I had some connection errors.
Yeah, that's okay. I was just asking that you quoted a decision of Peter Waweru. That,
Yes,
I believe, is a decision from the Kenyan High Court.
Yes,
so my question to you was, how did do you want this court to treat that, being that this is a decision of the High Court in Kenya in terms of its place judiciary?
Thank you, Your Excellency. We were persuasively using that particular decision to just make a point to this Honorable Court so that when it renders to make a decision, it relies on that particular case in a persuasive way.
All right. Thank you. That will be all from the state of Azania. We want to thank you for managing your time well and for your able submissions. May I now invite counsel for SECA to make their submissions.
Thank you, Presiding Judge. May it please this court, myself and my counsel, we are honored to appear before this honorable bench. My name is Nick Kimathi. I appear as lead counsel for the Coalition for Ethical Circular Apparel. I am joined today by my counsel, Timothy Kamore. With the 30 minutes graciously allocated to us, I intend to utilize the first 15 minutes to tackle briefly the issue of jurisdiction, issue 1, 3, and 5. My co-counsel will proceed to tackle issues 2, 4, and 6. Your Excellencies, the principle of sustainable development concerns the need to reconcile economic development with the environmental protection. This was first established in the case of the Gabshikovo Nagimoro's case, which was further reaffirmed in what we're dealing now more presently, the ICJ advisory opinion of 23rd July 2025. On to the first submission, Your Excellencies. I make reference to the ICJ advisory opinion of 2025 and that of ITLOS of 21st May 2024. What the ICJ advisory opinion of 2025 did is it reaffirmed the customary obligation to prevent significant harm to the environment. This was at paragraph 80. A nuanced reading of paragraph 235 of the ITLOS advisory opinion and that of ICJ at paragraph 281 reveals that both the ICJ and ITLOS have very deliberately and objectively refrained and restricted themselves from imposing any form of regulations and restrictions from any sectors in any industries and any economy. For this purpose, it is our position on behalf of SECA that the ICJ advisory opinion does not affirm a positive obligation on states to regulate transboundary value chains, including the second-hand apparel trade. For this, allow me to demonstrate before this honorable court through reports by the Center for Climate and Energy Solutions, where as of 2023, they reported that waste was in fact contributing the least at a 4% to greenhouse gases emissions. The leading contributions appear to be power industry with 29%, industrial combustion and processes at 21%, with transport coming in at 15%, fuel exploration and agriculture at 12%, and the buildings at 7%. Your Excellencies, it is very clear that these statistics demonstrate that waste, in fact, is not the main contributor to the emission of greenhouse gases. We ask that this may be extended significant weight as scientific information, as was espoused in the ICJ advisory opinion in paragraph 300, is indeed very important in determining the extent of the duties that is imposed on states. Your Excellencies, the second-hand apparel industry has various environmental benefits, especially in this particular context, which is very specific to the case of Azania. It not only extends the product life, but it reduces that need to acquire new garments and clothing on top of reducing the textile waste. For this reason, while we acknowledge that paragraph 281 of the advisory opinion of the ICJ does require states to in fact come up with measures such as administrative procedures and enforcement efforts to ensure that they regulate certain activities, the ICJ advisory opinion expects states to exercise this through the preserve of their state sovereignty. However, what the state of Azania has done is to go ahead in an arbitrary and discriminatory fashion to impose regulations and restrict trade to this sustainable industry. Your Excellencies, I move on to my second issue. The question that lies before this honorable court is indeed a very simple question, Your Excellencies. You are being tasked with the duty to determine whether or not these limitations that have been put on international trade are indeed justifiable. The position that we take as SECA is that they are not justifiable. For this, I make reference to the General Agreement on Tariffs and Trade, particularly Article 20, where we are informed of two particular conditions that need to be satisfied for these measures that they are imposing on the trade to be termed as justifiable. The first condition, Your Excellencies, is that they should not be a means of arbitrary or unjustifiable discrimination. The second condition being that they should not be disguised as a restriction on international trade. Let us look at the facts as lie is in the present case. The second-hand apparel trade only contributes to 4% of the greenhouse gases emission as provided from the Center for Climate and Energy Solutions. However, the state of Azania has gone ahead to put measures that restrict trade in these particular industries. Over and above, that was not enough. They have gone ahead to prevent 2.5 million people who are employed in this industry from accessing the market. They are not able to carry on with their livelihoods as a result of the measures that have been put in place by the TWCCEA. What this does, it is taking the guise of that restriction of trade, and they're pretending that it is in fact a lawful act. Seeing that it has failed both conditions from the Article 20 of the General Agreement on Tariff and Trade, it cannot be termed as lawful nor justifiable. The second test that we have before us comes from the International Convention of Economic, Cultural, and Social Rights, where Article 2 provides that no right in the present convention is to be applied in any manner that is discriminatory through any fashion or any kind of discriminatory application. However, looking at Article 7, you will notice that they have violated Article 7. Article 7 provides that every single person, everyone, each of these 2.5 million people has a right to enjoy just and fair working conditions. In no lens, when we look at these measures imposed by the Act, are they enjoying any just or fair working conditions? They are being restricted from accessing the market. Remember, the state of Azania is that of a developing economy, and therefore most of its people are low-income earners. These are people working in small-scale businesses that are not able to meet the standards of the digital infrastructure that has been put out by this Act. As having demonstrated that it does not meet this test as well, it is our position, and we do submit humbly before this honorable court, Your Excellencies, that these measures are not in any way justifiable. Allow me to move to my last issue, Your Excellencies, where SECA takes the position that the continued exposure to the pollution through their second apparel pollution is indeed a violation of binding international human rights. This is deliberately orchestrated by the state of Azania through their failure to implement measures that ensure there is proper waste management. The Committee on the Rights of the Child, through General Comment number 26 of 2023, had this to say on children's rights and the environment, where states have immediate and continuous obligations to protect the children from environmental harm, including waste from all sources. What this TWCCEA is doing is, instead of focusing on the obligation that has been imposed by this Committee of the Rights of the Child, it is going ahead to target the means of livelihood of low-income earners. Over and above, the United Nations Convention on the Law of the Sea, through Article 207, says this, that states shall adopt and regulate measures that seek to prevent, reduce, and control pollution of the marine environment from land-based sources. There has been no measures that have been put in place by the Act that seek to remedy the unregulated burning, the open disposal to coastal zones and the river systems, all of which are present problems that the state has been facing since time immemorial. Over and above, with regard to the intergenerational equity, the ICJ Advisory Opinion of 2025 had this to say on the same, that this is an expression of the idea that the present generations are trustees of humanity. Seeing that we are here on behalf of SECA to demonstrate before this court how Tanzania has not taken any measures to take care of the present environment in a good attempt to preserve the same for the upcoming generations, we ask that this honorable court finds in our favor that indeed the TWCCEA is in no way justifiable, nor are they upholding the economic rights of the people of Tanzania. I cede the floor to my co-counsel.
Thank you, counsel. Let me find out if Judge Cindy has any question for you or any clarification.
Thank you, Presiding Judge. I have one question for you, Kimathi. What is the role of other actors in environmental protection or climate change mitigation, in line with your argument?
Much obliged, Your Excellency. Allow me to seek clarification. Is your question specific to private actors?
Yes, it is.
Much obliged. We are here before you, Your Excellency, today to posit the notion that environmental protection is indeed vital and crucial. However, we should look at it from the lens where there is a balance that is struck between the environmental protection and the economic rights as envisaged through the ICJ advisory opinion itself.
Judge Cindy, we can, I think your question has now been clarified.
Yes.
Can we find out if Judge Njoki have anything?
Not from me, thank you.
Thank you so much. I think I just wanted to get something from your counsel Kimari, and this perhaps may also tie to the question Judge Cindy posed. Did I hear you to say that there is no positive obligation on the part of Tanzania to regulate transboundary waste?
Presiding Judge, I take note of your question. It is not to mean that we disregard paragraph 281 of the ICJ advisory opinion. It is only to mean that that particular provision does not specifically require states to impose restrictions on sectors such as the second-hand apparel industry.
Okay, I get. So are you then saying that there is an obligation? It's only that it ought not to be done in the manner in which that has been done. That's a sort of clarity that I wanted to get, because when
Yes,
you make such statement, then it is a statement of law, and I'd wanted you to also guide me on which articles of the various conventions that you're relying on to make that argument.
We are well guided, Your Excellencies. The legal authority which I am relying on is purely from the advisory opinion itself, seeing that it is drawn from 281 of the advisory opinion.
Okay. Thank you so much. You can have now your co-counsel, Mr. Kamore, making his submissions.
Thank you, Presiding Judge. May it please this court. Your Excellencies, my name is Timothy Mwangi Kamore, co-counsel for the Coalition of Ethical Circular Apparels, and I will be exhausting the remaining 15 minutes of the applicant's submission on issues 2, 4, and 5 respectively, then surrender our prayers conclusively to this court. Your Excellencies, I deem it only proper to begin my submissions with the words of Professor Patricia Mbote during the opening ceremony of the GLGI Moot Court competition, when she said, "Implementation and enforcement is the weakest link, not just the absence of laws." These words are particularly important before this court because the lacuna before this court lies in the enforcement vacuum that the Republic of Azania allowed to persist, and then now comes to impose protectionist shield measures to cover its historical failures. Every year, Azania imported tons and tons of apparel, knowing that 35 to 45% of its wastes were being imposed into the environment. And the inaction was a deliberate choice to keep the game going for domestic profit at the expense of regional safety, because a prudent state would not wait for a catastrophic misfire and then turn to its vulnerable population to impose arbitrary laws. On to issue 2 of the case. It addresses on the matter whether Azania's failure prior to the ICJ advisory opinion to regulate second-hand imports constitutes a breach of due diligence. Your Excellencies, the law is clear. From the ICJ in the certain activities case, they established that to fulfill its obligations to exercise due diligence, a state must ascertain if there is a risk of transboundary harm and whether this triggers the requirement to conduct an environment impact assessment test. And this coincides with the principle 15 of the RIA Declaration, which establishes the principle of precautionary measures, where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures. Allow me to also quote the 2025 advisory opinion that has been mentioned by the Council, Nick Kimathi. On paragraph 294, they confirmed this principle, holding that where there are plausible indications of potential risks, a state would not meet its obligation of due diligence if it disregards those risks. Therefore, a precautionary approach is an integral part of the general obligation of due diligence. If we look at the Inter-American Court on Human Rights advisory opinion that was released in July 2025, they recognized the right to a healthy climate as an autonomous right and derived from the right to a healthy environment, and therefore a duty of due diligence is recognized once the risk to the right of a healthy climate is identified. Your Excellencies, Azania breached this obligation because they possessed clear knowledge of the environmental harm caused by unregulated second-hand imports. They were availed with several scientific reports. For example, the government commissioned environmental audits revealed that between 35 and 45% of imported second-hand garments were unsellable upon arrival. Scientific studies further demonstrated that textile waste contributes significantly to the environmental pollution. And lastly, These impacts disproportionately affected children and coastal communities, and Azania still maintained a regulatory vacuum for decades, for 3 decades, Your Excellencies. If this is not negligence, Your Excellencies, I don't know what is, because after a decade, Azania, if they were acting in a reasonable and good faith standard as accorded by the due diligence, they should have imposed measures to mitigate these effects. But they continued to maintain that regulatory vacuum for decades, and then they come to impose the TWCCEA that I'm going to address in the subsequent issues. The argument on whether Azania lacked capacity to mitigate these measures, Your Excellencies, is inadequate because the second-hand apparel sector of Azania employs 2.5 million people approximately. This sector is not just a sector that stays there idly. This sector provides a clear tax and regulatory base for oversight. And they have enough, as provided by the International Law Commission, enough or bare minimum or adequate administrative status to impose measures that are according to its standard, according to its capacity. And therefore, the economic convenience excuse does not excuse the breach of a non-delegable duty to protect the climate. On to the second issue, Your Excellencies, in issue 4, I will address on whether digital traceability and extended producer requirements constitute lawful regulatory measures or unlawful discrimination. Your Excellencies, this issue is particularly important as it ties to the issue covered before by Council Nikki Mathi, and it covers on how these measures are unlawful, as issue 3 was covering why they are unjust. Your Excellencies, the TWCCEA Act is unlawful and arbitrary. Under GATT article, under the General Agreement on Tariffs and Trade, Article 3.4, as was highlighted before, important products, this article provides for the national treatment principle, where imported products must be accorded treatment no less favorably than domestic-like products. And this jurisprudence of the World Trade Organization establishes a two-tier test where there should be provisional justification under one of the paragraphs of Article 20 and application consistent with the Shapur requirement that was also mentioned by Councillor Nick Mathi against arbitrary or unjustifiable discrimination. If we look at the jurisprudence on arbitrary discrimination, Your Excellencies, the US gasoline case between Venezuela and the US, the US had adopted a measure regulating the composition and emission effects of gasoline in order to reduce air pollution in the United States. The appellate body, led by presiding member Florentino Feliciano, held that a measure cannot be justified under Article 20G if it is simply naked discrimination for protecting locally produced goods. And when a measure imposes no restrictions on domestically produced products, this is an arbitrary and an unfair measure and cannot be accepted or evenly substantially designed for implementing conservationist goals. When we look at the Textile Waste Control Act for Tanzania, it creates arbitrary discrimination, unfair treatment based on prejudice rather than reason. The digital traceability requirements imposed by the TWCCEA function as a de facto barrier to market entry that systematically discriminates against the informal sector. Because in Tanzania, the 2.5 million workers, the vast majority whom operate in these informal markets, have no access to digital infrastructure, capital, or technical capacity. And when the Act imposes mandatory digital passport grading requirements, this builds a technological wall that prevents access to these informal workers and favors the elite actors of the state. The Act requires individual garment tracking, Your Excellencies, a standard which is so sophisticated and resource intensive, while providing literally no technical assistance or transitional periods of capacity building to the informal sector. Under the principle established in the US shrimp case, They ruled that regulatory measures that impose single, rigid, and unbending requirements without accommodating the differing conditions and capacities of affected actors constitute arbitrary discrimination. On the EPR requirements, the extended producer responsibility requirements regime under the TWCCEA, they create unjustifiable discrimination because, according to scientific studies, Your Excellency, the textile waste from the country emanate from all sources, which means both imports and textile and domestic textile production. In the Brazil retreated tires case, selective enforcement that allows exceptions for domestic products while imposing strict measures on imports renders the measures discriminatory. Parliamentary debates, Your Excellencies, in Tanzania, deem this goal of textile production as reshoring and stimulating domestic circular social enterprises. This legislative...
5 minutes.
Much obliged, thank you. This legislative act is simply a naked discrimination for protecting locally produced goods. And therefore, as the act fails the necessity test, which was mentioned earlier, and since there are less alternative measures that Tanzania could have adopted, it does not satisfy the necessity test due to the point of entry qualification inspections that could have been implemented and the municipal waste management investments. On to the last issue, Your Excellencies, issue 6, on whether social enterprises operating within circular economy models may function as legitimate governance actors. The certified circular social enterprises are a disguised state barrier and therefore are not legitimate actors, governance actors, but rather they are instruments of protectionism, as I mentioned earlier, Your Excellencies, because the TWCCEA focuses on reshoring textile production and suggests that the social enterprise label is being used to favor domestic circular businesses over international exporters, as I mentioned earlier. And therefore, they use the social enterprise designation to create a technological role that exporters and formal traders cannot scale. This is definitely not a just transition principle that is emphasized in the UNFCCC and the Paris Agreement, where no man should be left behind. Appropriate measures in other countries like Brazil promote an inclusive model, and in India, where the CUEA incorporated vulnerable groups. The certified social enterprises is a sanctioned monopoly that lacks governance legitimacy, and therefore they should not and do not qualify for governance to be governance actors. Your Excellencies, as I come to the conclusion of my submissions, the TWCCEA is not an environmental measure. It's a vehicle for political patronage and a form of green pork barreling because they use climate-related subsidies and regulatory benefits to reward domestic political allies under the guise of circularity. And therefore, we respectfully invite the court to clarify, number one, that states have binding obligations under international law to regulate climate harmful value chains, including transboundary apparel and textile flows. But such regulation must be proportionate and non-discriminatory and must not unduly impair legitimate circular economy actors. Number two, that second-hand apparel and textile waste may constitute transboundary environmental harm where mismanagement contributes to pollution. Number three, international climate law as articulated in the International Court of Justice Advisory Opinion on Climate Change requires states to balance environmental protection with social and livelihood rights. And lastly, that circular economy actors engaged in reuse, repair, and resell from part of the climate solution and international law obliges states to recognize, support, and integrate such actors. Tanzania pulled the trigger for years, it must now be held liable for the damages. And with that, the respondents cede the floor back to the bench.
Thank you, councils. Before we move to hear any rebuttals, let me just find out from the judges. Judge Njoki, any issue you would want clarified by council?
Yes, I just have one issue. Mr. Kamoro, you've ended with a very strong note that the TWCCEA is what you would call disproportionate legislation to cover what your argument. And so I'm interested to know what less restrictive measures would SECA propose that address the documented harm that we are discussing today.
Thank you, Your Excellencies. SECA proposes the following measures that should be implemented in place of the TWCCA. Cognizant of the fact that the waste disposal management system is poor, we request and we deem it proper as an alternative measure for there to be imposed a municipal waste management system that would incorporate all the informal workers and recognize their role in managing the waste system rather than imposing an act that criminalizes all unsellable garments and excludes those informal sectors. We also find it proper that a measure which is inclusive is a phase-based approach, whereby digital infrastructure or incentives are provided to the informal workers so that they may help them reach this bar that has been set, where they, Your Excellencies, the informal workers are workers that have no access to digital infrastructure, and therefore imposing TWCCA upon them is something that is unreachable according to them. And therefore, if a phase-based approach is implemented, it will help them achieve such digital infrastructure through subsidies or incentives. Thank you, Your Excellency. Much obliged.
Thank you. I'd just like to do one follow-up. Now, based on that argument, is your stand that environmental regulation, such as the TWCCA, is inherently a rights violation? Council Kimathi can also weigh in. It's to both your team.
Thank you, Your Excellency. I shall begin. Yes, the measure is a violation of the human rights because according to the UNECE, a just transition, or according to also the Paris Agreement, a just transition should not, which emphasizing on some sustainable development, does not leave anyone behind and incorporates all rights in promoting a right to a healthy climate, at the same time recognizing a right to a livelihood and all the other rights and that are recognized under international law. Thank you.
Okay.
Your Excellency,
you have something you wanted to
thank you for the
add to that?
question. Allow me to respond while making reference to paragraph 300 of the ICJ Advisory Opinion of 2025, where it brings to light the principle of the variable nature of this duty of due diligence. In as much as we're saying that they are coming here to claim their duty was only to prevent significant harm from their duty was to prevent significant harm to the environment. However, it is very important that we are cognizant of paragraph 300, which I will read. Having considered certain elements of the due diligence standard, the court notes that their proper application in a specific situation may be a complex operation due to the variable and evolving nature of the standard. Seeing that Azania is only but a developing state whose economy is equally developing, that is characterized with low-income earners, we are simply not in a position to yet imply that we are ready to take up the measures put in place by the TWCCEA. However, alternatively, as my counsel Timothy Kamore has exhausted, they can put very possible and feasible measures in order to ensure that waste management and disposal systems are up to par.
Okay. Thank you so much, Judge Cindy. Any issue you wanted clarified?
None from me, Presiding Judge.
Thank you. I have none that I would want to pose to the team. I believe now we will go to the rebuttals from the team in terms of the arguments that have been put forth. We'll begin by the rebuttals for counsel from Azania. You have 10 minutes. You can share that time, or one of you can use it, but you have 10 minutes, so you can begin.
Presiding Judge, Your Excellencies, thank you for the opportunity once again. My name is Rachel Praise for the state of Azania. I will proceed by stating that it is quite unfortunate that our friends, counsels for SECA, have stood before this honorable court and misled this court on the facts of the case. If you may permit me, Your Excellencies, and move with me to page 3 of the factual matrix, which states what the TWCCEA introduced. And that is 1, the extended producer responsibilities for apparel importance. Number 2, digital traceability and grading requirements for second-hand clothing imports. Number 3, minimum quality thresholds prohibiting the importation of unsellable garments. Number 4, formal recognition of certified circular social enterprises as ecosystem partners. And lastly, mandatory environmental and social impact reporting. Our friends, the counsels for SECA, have stood and said that these provisions are arbitrary and go against human rights. And I will proceed to try and explain or shed light before this court what those provisions aim to do. So for the extended producer responsibility for importers, by requiring importers to register and pay fees, the state internalizes the polluter pays principle in order to ensure that the costs of waste management and recycling are borne by the entities profiting from the trade, and rather than pushing these obligations only to the state. This helps in ensuring that all actors who have caused environmental harm do pay for the pollution that they have caused. On the digital traceability and grading, digital traceability is a targeted tool to combat the opaque nature of apparel supply chains. This measure we submit that this measure is proportionate because it focuses on data transparency essential for verifying that the imported goods are not contributing to illegal dumping or transboundary pollution. Your Excellencies, on the minimum quality threshold, prohibiting unsellable garments, which constitute up to 45% of the waste in the state of Azania, is a direct prevention measure. So when secondhand clothing is actually textile waste, it creates a significant local environmental degradation. And that is what the state of Azania aims to achieve by enacting the TWCCEA. On the recognition of circular social enterprises, this measure ensures that the regulatory framework supports, other than just displacing the informal and social economies often found in the global south, by certifying that these enterprises, the state fulfills its obligation to protect the right to clean and healthy environment. And lastly, on mandatory impact reporting, this is a standard tool to ensure that the parties that are engaging in second-hand apparel trade provide the state with the data that is needed in order to fulfill the continuous monitoring obligation of the state to ensure that the apparel value chain remains with permissible environmental limits. And therefore, we still stand and say that these measures were a proportionate and necessary measure in order to combat the effects of climate change, and transboundary border harm. I'll now pass the baton to my fellow counsel to proceed on rebuttal on the remaining issues. Much obliged.
Thank you once again, Your Excellencies. I am again Peter Manuele, and I shall be picking on the baton of rebuttals from my co-counsel. And I only have one particular issue to address with respect to due diligence. Your Excellencies, councils representing SECA have had the chance to demonstrate before this honorable court how the second-hand clothing had violated environmental rights, including human rights of the children. And they even mentioned the particular, the UN Committee on the Rights of the Child. The particular comment on protection of children from the triple planetary crisis of climate change, environmental degradation, and biodiversity. Your Excellencies, all these aim at showing the making of a desperate move, which I would like to avert before this honorable court that actually these positions were affirmed by the international and regional regional courts, where the Supreme Court of the Republic of Tanzania and the African Court on Human and People's Rights also affirmed that indeed this particular act, which has been enacted in response to the International Court of Justice advisory opinion, which requires states to make regulations to combat environmental harm. So in essence, the reason as to why the Republic of Tanzania made this particular act, which the Supreme Court and the African Court on Human and People's Rights has affirmed that indeed it is in line with international human rights law and environmental law, it is a clear indication that indeed Tanzania was exercising its due diligence to prevent environmental harm. With that, I seek to end my rebuttal on that point. Thank you, Your Excellencies.
Thank you so much. May I invite now counsel for
we should
second.
flow back to the courts for any clarification or questions.
Given that we were doing rebuttals, I think we just want to go straight to the SECA team to now take their 10 minutes. Thank you so much for your presentation. Council Nick and Nick Kimathi and Timothy Kamore, are you still with us, or
Yes,
you've fallen off the platform?
Apologies for the technical difficulties, but we have made successful attempts to rejoin the platform and the proceedings.
Very well. You have 10 minutes to do your rebuttals. And if your systems are now up and running, you may begin now.
Yes, we are well read, Presiding Judge. We'll take 4 minutes to make my submissions with regard to the rebuttals, and my co-counsel Timothy Kamore will equally use the remaining time, 6 minutes, to make his submissions on the rebuttals. Your Excellencies, they have made assertions that indeed they do not violate the economic rights of the people of Tanzania. However, we come here back to shed light on Article 7 of the International Convention of Economic, Cultural, and Social Rights, which entitles every single person, everyone, out of the 2.5 million people should be able to access and enjoy fair and just working conditions. The measures they have put in place don't allow each and every single of the 2.5 million people to access the market, to enjoy fair working conditions, nor just working conditions. They should be able to simply carry out their trade, which is quite sustainable, keeping in mind and noting that the state of Azania enjoys significant environmental benefits from this second-hand apparel trade for the various benefits that we enumerated before this honorable court. Moving on, I would like to shed more light on the principle of common but differentiated responsibilities and respective capabilities as espoused in paragraph 290 of the ICJ advisory opinion, where the court takes note that different states have different capabilities and resources. This proportionally informs the abilities that they have to respond to climate change, and it equally is a direct indication of the negative impacts they have had on the climate themselves. The same has also been supported by the Inter-American Court advisory opinion, where it acknowledges that not all countries have contributed equally to climate change, nor do they have the same resources to address it. Therefore, states' economic and technical capacities, specific needs, and developmental pathways must be considered. This was through paragraphs 257 all the way to 265. Your Excellencies, allow me that in the same note that I started my submissions, to close with that statement from paragraph 147 of the advisory opinion that the need to reconcile economic development with protection of the environment should be taken very seriously, and it should not be in a lens that undermines either. We are only asking that they take note of the livelihoods of the people of Azania. That having been said, I welcome my co-counsel to proceed with the rebuttals.
Thank you, Presiding Judge. Your Excellencies, the Republic of Azania presents its conduct as that of a wise builder. Yet its foundation is not built on rock, but on a selective reading of the international law that treats due diligence as a license for indefinite delay. They have told us that due diligence is a variable standard to justify their breach. However, the Inter-American Court on Human Rights poses that economic convenience does not excuse the breach of due diligence or an undelegable duty as such. They have used the excuse of no equal effective measures to justify the necessity test under the World Trade Organization jurisprudence and general agreements on tariffs and trade. However, Your Excellencies, it is our submissions that there were effective alternative measures that could have been adopted instead of imposing such arbitrary acts that criminalize and penalize and infringe on the rights of these vulnerable groups, such as the women and the youth, who are the majority of these informal sectors. They have lastly termed the circular social enterprises as governance actors. But Your Excellencies, it is our submission that this is just a guise of a political patronage, a guise to enforce and promote the elite-driven model. They do not abide by the just transition principle, and they do not abide by the sustainable development principle, where economic rights and social rights should be balanced and are mutually exclusive. And with that, I cede the floor back to the bench. Thank you.
Thank you so much. May I, on behalf of the bench, take this opportunity to thank all the councils for their erudite submissions. The court clerk is going to give us guidance. The judges are going to retreat to consider, and then we will get further guidance from the court clerk.
Thank you so much, Presiding Judge. That marks the end of submissions for both sides. I now respectfully request the honorable judges to retire from the public courtroom and proceed to the chambers for deliberations. To the rest of us, kindly remain on the call as we await the return of the honorable judges for delivery of the determination in 10 minutes. Judges, you can log out. We meet at the chambers. Ladies and gentlemen, we are back from the chambers. The judges will be joining us shortly. They are here. Are the participants here? I'd like to use the authority bestowed on me by the courts to give you your feedbacks. If you can just switch on your cameras so that I see you. Nick? All right, so we'll start with Rachel. Rachel Praise. The bench notes that you are good in making your arguments. However, you are referring, whether you are reading too much. The bench also notes that you had not internalized, or it appeared like you had not internalized the concept well. You gave little eye contact to the bench. Reference to the documents presented did not come out clearly. However, it was indicated that your arguments need to be thought through for them to be perfected. Your counterpart, Peter, the bench observed you are creative in your language. However, you are also reading too much, but you had interludes in between, which made it more engaging. You also dished out a quote here and there, which also made it engaging. You understood the subject, the bench notes. However, when you were asked a question by the bench, you took a bit of time to refer to your notes, and in fact telling the court to wait for you to locate your notes, which is not court etiquette, so that one should be checked into. You have a good potential for advocacy, and the bench also notes that for both of you, read more books, read more legal reasonings, read more judgments so that you can have the vocabulary. Sometimes you are running short of words to use, so do more reading to get these vocabularies. To the counsels for SECA, Nick Kimathi, your confidence has been noted by the bench. The bench also notes you understood your brief. The bench was also impressed when you sought clarification from a question which you were asked, meaning you kept the bench engaged. The bench also indicates you had good eye contact, you are not reading too much. The bench notes you had strong exposition of the law. The flip side of the praises I've dished out to you was that in clarity of your responses, you need to look for materials to back up your answers, either if it is legal case laws, legal treatises, advisory opinions, but always when you are dishing out your feedback, ensure you back them up. And then your time management was also splendid, as has been noted by the bench. For your counterpart, Timothy Kamore, very good command of the law. Your confidence was also noted by the bench. You understood the topic really well, elaborated your arguments, you articulate, and you used very creative language of which the bench was impressed. The downside, sometimes you forgot we are in a virtual judicial court session and you used debate language. So kindly please note on the court language, especially when you are referring to your opponents. All right. So as I've this, the evaluation rubric that has been used to give you your marks and to assess you will be availed on your emails shortly after this, so that you can know under the different heads what you have scored, as well as these comments that I have read to you. They'll also be on that judicial score sheet so that you can follow and you can improve. At this juncture, I'd like to return the session to the presiding judge to deliver his determination. Presiding judge, welcome.
Thank you, Court Clerk. Councils, we took a bit of time with the judges deliberating. It wasn't an easy decision. We looked at the various aspects. So the first aspect we looked at was your knowledge of the law and how you then applied that knowledge and the analysis of it. We also looked at how you had structured your arguments and the clarity of the arguments and the kind of advocacy skills that you displayed as you made your arguments. We also looked at your use of authorities and your responsiveness to the bench and the questions that have been posed. Overall, we want to say that we are, as a panel, extremely grateful for your arguments and the level of preparation that you put into this. It was evident that you had prepared very, very well for this assignment, and we are grateful for that preparation. Our final analysis in terms of the marks is that we gave Chuka University, which was counsel for Azania, 70%. Out of the different score heads that we were making, we gave them 70%. And the Catholic University, which was representing SECA, the winners of this session for today, and we gave them 81%. On behalf of the bench and my fellow judges and the court clerk, we want to wish you all the best in your future endeavors, and once again to thank you for your very able and erudite submissions before us. Thank you, Court Clerk. You may give the final directions.
Thank you so much, presiding judges. Thank you for your verdict. Congratulations to Catholic University. Having in mind you joined this competition a day before it was launched, you had little time to prepare. Thank you for that submissions. Thank you to Chuka University. Remember, as we indicated, losing a session does not mean you are now out of the competition. Remember, it's the top 8. So still both of you can proceed depending on how the others will perform. So there are no losers, but all of us are winners and we are willing to learn. So GLGI 2026 takes a break. The next session will be on Monday, the 13th of April 2026, between Herbert Chitepo School of Law of Zimbabwe and Jomo Kenyatta University of Agriculture and Technology, Kenya. So until then, we wish you the very best. Judge Matthew, I see you on the bench. I see you on the platform. Before we go, could you please just greet our participants? and wish them good preparations. Judge Mukole, are you with us?
Yes. Honorable Presiding Judge and judges, participants, and the clerk, today Brian himself, I congratulate all of you, the bench, and indeed the participants. My observation is that the score could have gone either way. I think both teams were very, very eloquent and discharged their duties as counsel extremely well. Congrats, and as Brian says, they see opportunity to go forward. So don't leave your notes behind. Make sure you keep on preparing. You never know. Have a very good evening. Thank you very much, Judge Theory, Judge Cindy, and where is the other judge?
Njoki.
Joki. Asanteni sana na kwaheri ya kuonana.
Thank you so much, Judge. If there's no other issue from the bench, the court is functus as officio. You are free to leave the platform. Have a good evening. See you next week on Monday.
Good evening, everyone.